Welcome to Oil and Gas Law with Energy Law Prof. This lesson is about the implied covenant to market, the duty of the oil and gas company to get a good price for the natural gas produced from a lessor's lease. And we'll also talk about the marketable product rule, which is used in some states and can require the oil and gas company to do some things to raise the price of natural gas without charging the landowner, the lessor, for it. So first, we're going to talk about implied covenants. We've actually mentioned some implied covenants, like the implied covenant to test, earlier in this class, but this is our first chance to talk in depth about an implied covenant. So let's talk about where they come from. So the implied covenant is basically a term in the lease that is not written. So it is simply implied by the courts, and we'll talk about the reasons that the courts will imply certain promises on behalf of the lessee, the oil and gas company. Now, in theory, there can be implied covenants, implied promises for both parties, and so they can bind the lessor or the landowner. So, for instance, the lease may not specifically say that the lessor or landowner shouldn't prevent the oil and gas company from coming on the property to drill, that it shouldn't barricade the roads that the oil and gas company needs, but that's an implied promise in the lease. There are a lot more implied covenants that are imposed upon the lessees, the oil and gas companies that protect the lessors. So usually when we talk about implied covenants, we're going to be talking about implied covenants that lessees made to help the lessor. So why do the courts imply promises that aren't explicitly stated in the lease? Well, the basic reason is that most of the money under a typical oil and gas lease comes from a royalty, from that share of production. And so that means that unless there's production on the land, the lessor, the landowner, won't get anything. And so the courts have tended to imply promises by the lessee oil and gas companies to ensure that there's enough production and that royalty is sufficiently large for the lessor, the landowner. So the lease gives that lessee, the oil and gas company, the exclusive right to produce oil and gas, and so the courts want to make sure that the oil and gas company uses that to produce oil and gas and benefit the lessor. So there's a lot of these implied covenants. We're going to talk about some in just on the next slide, but we've talked about the implied covenant to test, which is this duty that the courts imply that wasn't written in any lease to drill for oil within the first year of that primary term. And nowadays, mostly oil and gas companies get rid of that duty by paying delay rentals or saying it's a paid-up lease. There are other covenants as well, like to develop, to further explore, to market. So here, in a little bit more detail, one of the common implied covenants is to protect against drainage. And so that means that when you have a lease on your land, the expectation is the oil and gas company is going to develop that lease fast enough that all your oil won't be drained off by neighboring properties. And so that covenant to protect against drainage can be very important. It can actually be very important even when the oil and gas company has the lease on the neighboring lands, because basically it can protect you from having the oil and gas company favor your neighbors who have a lease with the same company. We talked about that implied covenant to test. There are a couple other covenants, like to reasonably develop and to further explore, that there's been a lot of dispute about their meaning. They can sometimes protect a landowner if the oil and gas company really isn't producing the vast majority of oil and gas on the property. It's only operating on a corner of its lease and trying to maintain the lease with a single well. We'll talk about that in a later class. But today we're going to talk about the duty to market, to get a good price for the natural gas produced from a property. And we can think about either a separate implied covenant or maybe one that encompasses the other ones, which is the duty of the oil and gas company to operate diligently and prudently. Okay, where do these implied covenants come from? They're not in the text of the lease. Why do the courts imply that? Well, one theory is that the parties would have agreed to this. It's just that, look, the lease is a short document, and it's negotiated in a limited period of time, and so the parties don't have time to write out all the really implied promises that they really meant when they made this agreement. And so these promises were intended, they just weren't written down. Now, note that if this is the reason that the courts are implying covenants, it suggests that if the landowner and the oil and gas company don't want to make those implied promises, they could just say so. They could say, no, we really did have time to write this down, and we just don't think there should be an implied covenant to test. And you see that with the leases that disclaim that duty to test, to drill within 1 year, and they say, no, we'll just pay a drilling delay rental instead. Okay, another theory of where these implied covenants come from is that there's an imbalance of power between that lessee oil and gas company and the lessor landowner. And so even if the parties would have not agreed to impose all these implied duties, nonetheless, the law should imply them, because that's going to level the playing field between the lessors and the oil and gas companies. And without these implied duties, the oil and gas companies would just be too slow to drill on property, and the lessor wouldn't have enough protection in the form of a duty on the oil and gas company to drill quickly and get a lot of money for the oil and gas on the property. So note that the implication of this theory of implied covenants is that it shouldn't be possible for the company and the landowner, even if they agreed to get rid of these duties. Now, there's a couple other theoretical origins of these implied covenants, like the cooperation principle. And these tend to be kind of a mix of that in fact theory and the at law theory. So the cooperation principle says, look, it's good for society if there are cooperative relationships between oil and gas companies and landowners to ensure orderly development. So we're going to imply some duties as a result. And you might think about, in that circumstance, okay, we think it's good for society to have these duties. Does that mean that the parties shouldn't be able to contract out of them? Or are we just presuming this and the parties should be able to deny these implied covenants if they like? Another theory that kind of mixes those in fact and at law theories is the idea that the lease is a relational contract, and it can't spell out all the terms that will govern this relationship that might last decades. And so we're going to imply some covenants that better manage that relationship. And because, again, it's that mix of sort of the presumed intent of the parties and some of our public policy goals, it's a little bit unclear whether that theory would allow the parties to contract out of these implied covenants. Okay, so let's say you're an oil and gas company and you violated an implied covenant. You didn't prevent drainage from the lessor's property. Perhaps you didn't market for the right amount. What are the remedies? Well, the remedies often are going to be damages. There can even be punitive damages in certain circumstances if the oil and gas company's conduct was bad enough. There also can be lease cancellation. Now, that was used more historically. Nowadays, courts would be less likely to cancel the lease immediately. They might be more likely to use conditional cancellation, which says, look, you didn't meet one of the implied promises. I know it wasn't written there, but you're not living up to your duties. And so, therefore, unless you drill another well or look for more oil right away or do something to improve your performance on this lease, we're going to cancel it. So it's a conditional cancellation, not right away, but if the oil and gas company doesn't do what the landowner is requesting. All right, so let's talk about the implied covenant to market. There's a couple key components. The first is that you have a duty to sell the natural gas from a natural gas producing well within a reasonable period of time. So although you have the right to shut it in and pay shut-in royalties, you can't just shut it in without thinking about whether there's a market. You have to work diligently to look for someone that's going to be willing to purchase that natural gas from you. It may take you a while to do so, but you need to show that you are working diligently to find somebody to purchase that natural gas. And if you don't, you might forfeit the lease. Okay, another aspect of the marketing covenant, and the one we'll focus on today, is price. So the lessee has a duty to act in good faith to get a good price for the natural gas. And the reason that price is relevant is, of course, because it's 1/8 or whatever fraction you're using, a 1/8 fraction of the amount that's paid for the gas, the amount realized, or the proceeds that is most often shared with the lessor. And the lessee has a duty to act in good faith to maximize that price. Now, Now, no, normally, this would be in the lessee oil and gas company's interest as well, because although 1/8 of the gas belongs to the landowner, 7/8 belongs to the oil and gas company. And so normally, they're going to be looking for a high price for both their 7/8 and the landowner's 1/8. There can just be particular circumstances where they have other incentives that prevent them from bargaining for a good price, and in those circumstances there may be a violation of the duty to act in good faith to get a good price. Now, some cases actually say that the oil and gas company has an affirmative duty to find the best available price. Others say it's a reasonable price. There's not actually a super clear standard, but the overall key is that the lessee oil and gas company has to be acting in good faith to provide a good price for the lessor's gas, the lessor's share of the gas. Okay, there are some limits on this marketing covenant. So remember what we said about market value natural gas royalty terms in Texas. So market value ones means it doesn't actually matter how much money the oil and gas company gets for its sale, because the oil and gas company owes 1/8 or whatever fraction of the market value of the gas that's sold, and that is measured independent of what the oil and gas company sold the natural gas for, because it's the market value at the time of natural gas in that time and place and of that quality of natural gas. So in those circumstances, the oil and gas companies under no duty to maximize the price received for the natural gas, because that doesn't affect the price that's paid to the landowner. It's really on the oil and gas company. If it wants a little less money for all that natural gas it's producing, no problem, because that doesn't reduce the recovery for the landowner. So obviously the pricing aspect, the marketing covenant, doesn't matter when the lessee owes a market value royalty in states like Texas that use that majority rule, that VELA rule that we talked about. Now, in states that use that TERRA rule, where even if the lease says market value, still what the landowner gets paid is a share of the proceeds or the amount realized, the amount of money that the oil and gas company got. In those circumstances, then yes, absolutely, there continues to be a implied covenant to find a good price, because that price will be shared with the landowner. Let's talk about this Amoco versus First Baptist case. This is a case that's important to read carefully to understand what's going on. It's a case from Texas in 1979. It's on page 332 in your 8th edition textbook. Okay, the lease, fairly typical one, pay to the lessors 1/8 of the proceeds received by the lessee at the well for all gas produced from the lease premises and sold by the lessee. So this is a proceeds lease, and so we're sharing with the lessor the 1/8 of the amount received, right? The amount realized. Now, in this case, what did Amoco do wrong? I think it can actually be useful to look at page 333, because you have to look at these pricing terms. So effectively, what happened in this case was that Amoco had made a very bad deal to sell natural gas in the past. And so it was selling natural gas for 17 cents an MCF, okay? So that was a very low price, because as you can see on page 333, the average price at that time was much higher. It could be something like 10 times higher. And so Amoco was very concerned about this long-term contract in which it was selling natural gas from other leases, not First Baptist lease, at that low price, 17 cents. And so what it did is it said, okay, I've got the way to solve this. The company that's buying natural gas from me at 17 cents is, of course, very happy with this long-term deal. The problem for them is that eventually the leases that I'm selling natural gas to them from at 17 cents are going to run out. And so that contract's going to end. They got a great deal now, but it's going away. And so I think I can get them to sweeten the deal and raise it from the old 17 cents up to 70 cents. Now note that that is still about half of what the current price is, but it's a big increase in the price. And the way I'm going to get them to do that, you might wonder, they got this great deal. Why are they so generous to Amoco? Well, the reason is Amoco says in return for raising the price really 4 times higher from 17 cents to 70 cents, I am going to put more gas wells under that contract. So it's going to last longer for you. So from my perspective, I get a big bump up in the price, but from your perspective, it lasts longer because there's more gas wells attached to it. And one of the gas wells that they put under it is First Baptist. And so, of course, that works out maybe great for Amoco and the company that they're selling to, but it's bad for First Baptist, because if instead of taking this natural gas well and selling it under the old contract that was really bad, they had just sold it on the free market, instead of being worth 70 cents, it might have been worth $1.40 an MCF. So it might have been worth twice as much. And so for that reason, the court here holds Amoco liable. And Amoco had to meet this duty of good faith, and basically it was giving away First Baptist's gas for a low rate to solve some other problem it had under a different unrelated contract. So this is a good example of how, although it seems like wouldn't oil and gas companies just want to sell your gas at the highest price? After all, 7/8 of the natural gas belongs to them. Sometimes, because they have a complicated web of contracts with third parties, etc., they might give somebody a very good deal on your gas to get a better deal on some other gas that they have. And the court here says that that is not in good faith. Okay, you could think about this as in some ways an aspect of a general, reasonably prudent operator standard. And that's been described in different ways. But one way of thinking about it is what a reasonably prudent operator would do, but has to take into account both the interests of the lessee, the oil and gas company, the operator, and the interests of the lessor, the landowner. So that's going to include a couple different considerations. One is, of course, competence. And there's no suggestion that Amoco was incompetent here. I mean, honestly, they may have been serving their interest quite well. But it also means good faith and due regard for the lessor. So they have to be operating in a way that takes into consideration the lessor's interest. As we said in a previous lesson, it's not a fiduciary duty. So they don't have to put the lessor or landowner's interest above their own necessarily, but they do have to have due regard for that interest and treat the lessor in good faith. What does that mean? Well, the courts have really struggled to define it. So we don't have a perfectly good idea. We know that they don't necessarily have to always serve the lessor's interest over their own, but they do have to take account of that and treat them with good faith and due regard, whatever you think that means. Okay. So, some other issues that arise under proceeds, leases. One big question we've already talked about is what payments are included. If there's some kind of side payment for a demand charge or otherwise, is that included? Another question that often arises, a lot of times, a natural gas company is going to sell to a company that's affiliated with it. Does that meet the marketing covenant? You're probably going to want to show in that case that there weren't other better prices available. Because what you're suspicious of is that they're selling the natural gas at a low price to limit the royalty that's paid to the landowner. And of course, it limits the price for the natural gas company as well, but maybe they don't mind because it's giving cheap gas to their affiliate and helping their affiliate make bigger profits. Another question is, how high does the price have to be to meet the standard of that implied covenant? One thing you might wonder is price the only standard? When natural gas companies sell their own natural gas, a lot of times they're willing to give on price a little bit to get a promise to purchase the natural gas for a long time to come. And so presumably a landowner might have the same interest. Another question is, can the amount realized be less than the market value and still be prudent? Remember, we have all these ways of trying to estimate what the market value of natural gas was in a particular place. If you can show that that market value was bigger than the amount realized, can that sale be prudent? I think in general it probably could be. It may be that you made a reasonable deal for long-term sales of that natural gas, and it just turned out that something unexpected in the market happened, and so the market value jumped above the amount of money you're getting from the well. And so I think in theory it can be prudent, but you should just know that if it's quite clear that the market value is higher than what the landowner is getting, that's the kind of situation that can often result in the landowner suing you in litigation. All right. We're going to talk now about a very important issue that leads to frequent litigation in the oil and gas industry, which is the idea of when is natural gas finally produced. Now, Texas follows what might be intuitively make sense to you, which is that Texas says when natural gas reaches the top of the well and it's captured and held, it has been produced. And so when the lease says that you're supposed to get 1/8 of the value of the natural gas that's produced, that's 1/8 of the value that the natural gas had when it got to the top of the well, when it was captured and held. That makes a lot of sense intuitively. But a lot of states follow a different rule, and I'm going to explain what that means in terms of compression costs in a second. A lot of states follow what's called a marketable product rule. And they say, you know what? It's not really produced, the gas isn't produced, when it gets to the top of the well. Because in a lot of circumstances, nobody's willing to purchase the natural gas at that point. A lot of times, before it is marketable, before it can be sold or marketed, it has to be transported somewhere. It has to be cleaned up. It has to be processed. Sulfur has to be removed. It has to be compressed. And so it's only when all of those things have been done to make it marketable, so it can be sold or marketed, it's only after that that it is a marketable product. And so oil and gas isn't really produced, or at least natural gas isn't produced, until you've done all those other things for it. Now, the implication of that is that the 1/8 that you receive of the value of gas produced can be substantially larger, because at that point, the oil and gas company has done all these things like compressing, transporting, processing the gas to make it more valuable. And so the capture and hold rule in Texas says that you get 1/8 of the value of what's produced at the wellhead, but the marketable product rule says you get 1/8 of what's typically larger, the natural gas that is not only brought out of the wellhead, but also transported, processed to where it can be sold. So to give you an idea of that, we have this chart again, which shows oil and gas flowing from upstream. You can imagine the oil going down the mountain to downstream. And by the time that you have taken all those steps to make it more valuable, it could be worth $3 an MMBTU. And so after it's more valuable, then in those states that follow the marketable product rule, they would say it's only marketable there. So when you ask for 1/8 of the value of the production of natural gas, you're talking about 1/8 of $3. Now for Texas, they would say, no. The natural gas was produced at the wellhead. And so when we ask for 1/8 of the natural gas produced, you're talking about 1/8 of $2. Now remember, typically we don't actually have a price at the wellhead. And that's because the sale happens later when, according to the states that follow the marketable product rule, the natural gas is marketable. And so to figure out in Texas and capture and hold states what the natural gas was worth at the well, we use that netback method where we say, well, it was worth $3 downstream where it was sold, but it cost $1 to gather, transport, and process, and so therefore at the well it was worth $2. Okay, this marketable product rule can involve a lot of litigation because it is complicated. It leads to disputes about the value of natural gas, and so there's a lot of litigation here. Now, to look at an example case that follows the rule in Texas, which is the capture and hold rule, you can look at this Piney Woods versus Shell. We just have a little description of it. You don't have the full case, but this was a case where Shell was producing sour gas, so gas with sulfur in it. And so, of course, they had to spend money to take out the sulfur, so they had processing costs. Now, they deducted that from the royalty they paid because they said 1/8 of the value produced, that's 1/8 at the well because it's produced at the well, and the court approved that. It said, yeah, all right, you can make those deductions to find out what the gas is worth at the well because it was produced when it hit the wellhead. Let's look at a case in a jurisdiction that follows the marketable product rule. Kansas follows the marketable product rule. This Fawcett versus oil producers case, it's from 2015. It's on page 346 in your book. In this case, what happened is that the oil and gas company knew it had this marketable product rule that said it's not really produced until it can be sold, until it can be marketed. And so the oil and gas company said, well, wait a second. I know what that means. If I spend all the money to improve it, to make it worth $3 instead of $2, I'm not going to be able to deduct any of those costs from what I pay to the royalty owners. So you know what? I don't want to do that following this marketable product rule. I'm going to find somebody who's willing to just come and buy it at the well for $2 because it's not worth it for me to spend all this money upgrading it if the landowner's not going to help me pay for that. Now, the landowners didn't like that. They said, okay, yeah, we're supposed to get this bigger amount from where it's sold under the marketable product rule, but we'd really like you to do something to increase the value of this natural gas before you sell it, because that's going to get us more money overall. So the royalty owners say, you know what? You should have transported this gas. You should have processed it and compressed it to make it worth something more. Now, the royalty owners say, look, yes, literally you sold it, but that's not what it takes to be marketable. To be marketable, it's going to have to be really a good product that sells for a good price. So you should have transported it to a market where it was worth more rather than selling it for $2 at the well. The court says no. They agree with the oil and gas company. They say, look, this gas was literally marketed. It was literally sold, so it was literally marketable. They met the marketable product rule. So you note that even in a marketable product rule state, if it can be sold at the well, then it might be that the capture and hold rule and marketable product rule operate in the same manner in that instance, which is, look, it can be sold at the well, so as in Texas, we're going to value at the well, you're going to get that 1/8 of that $2, not of the $3 that maybe it could have been sold for if you had found, if you had done some other things to improve that natural gas. Now, some states that follow the marketable product rule actually do require what the royalty owners are saying here, which is they say, yeah, we want it to be marketable. And by marketable, we don't just mean literally it could be sold. We mean that the oil and gas company has put it in a good condition to sell it for a little bit more to benefit the lessors. The Kansas court here rejects one of those courts, which is Colorado. And Colorado had a decision that arguably said that the oil and gas companies, even if they literally could sell the oil or literally could sell that, could market that natural gas, they should go further and further improve that gas to bring it to a commercial marketplace where it would be worth as much as possible. So here you can see a split between states that follow the marketable product rule. Some of them say, well, I guess as long as you can sell it, it is marketable. And others who say, no, to be really marketable, like we're talking about, you need to do something to improve the value of that natural gas. All right. So where does this marketable product rule come from? As I said, it might be more intuitive to follow that Texas rule and say, look, it's produced once it gets to the top of the well. Well, there's a couple different theories about where it comes from. So one theory is that, look, there's this implied covenant to market and to get a good price for the natural gas. And so along with that comes the implied covenant to improve that natural gas until it's really a marketable or good product. Another theory is that in the lease, when it says to produce, you get to keep the oil and gas lease as long as oil and gas is produced, what it means is paying production, profitable production. And so therefore, it shouldn't be enough that literally you have some natural gas at the wellhead, that you should be required to put it in a condition where it can be sold for a profit. And you see that is a theory espoused by one of our co-authors on this 8th edition book. Now, there are some problems with the marketable product rule as well. One problem is that, as we'll see in a future lesson, it can sometimes allow implied terms of the lease to override express terms. So it's very common in a lease to say that the natural gas is valued at the well. But for states that follow the marketable product rule, they'll say, well, no, we want to value that natural gas wherever it finally becomes a product worthy of sale, wherever it becomes marketable. And so even though the lease would seem to say you get that lower $2 price, the marketable product rule would say you get that $3 price for when it's transported to reach some market. Another problem with it is that it can be economically inefficient, because remember that the oil and gas company and the lessor landowner in theory have the same interest, which is that they should want to transport it and process it and compress it to do all those things to the natural gas, if doing so raises the price of natural gas more than the cost that you spend on each of those things, and that would be economically efficient. The problem is that if the landowner doesn't contribute to those costs, on the margin, there will be times when the oil and gas company says, you know what, it might be more efficient to ship this natural gas, to process, take out the sulfur, compress it, but we're not going to do that because if we do it, we won't get paid back for it. And that's just basically a benefit to the royalty holder. They don't pay for it in any way. So it can lead to inefficient failure to sufficiently process natural gas. Another potential problem is that it can require a factual determination, which is this product marketable? That could change month to month, because maybe one month somebody's willing to buy the natural gas at the well and the next month they're not willing. And so did all of a sudden the product go from being marketable to not marketable overnight? It absolutely can, and really can change day by day. Another theoretical challenge with the marketable product rule is, isn't every product marketable at some price? Now, you can think about how far you want to take that theory, because as we've talked about, sometimes the price for natural gas at the wellhead is zero, or sometimes it's actually negative. And I guess negative is a price, but the idea of this criticism of the marketable product rule is that, of course, every product can be sold at some price, whether positive or negative, and so it doesn't make sense to say that there's one point where it all of a sudden becomes marketable.